Teams and arbitrators, thank you for joining us today and welcome to the semi-final round of the International Commercial Arbitration Moot Championship ICAMC 2021. My name is Changwani and I'll be acting as the bailiff for today's session. We will now proceed to the dry run session. Hi, lead counsel from Claimant. Can you hear me and see me?
Yes.
Thank you. Second counsel from Claimant. Can you hear me and see me?
Yes.
All right, thank you. Lead counsel from Respondent. Can you hear me and see me?
Yes.
Thank you. Second counsel from Respondent. Can you hear me and see me?
Yes, I can.
All right, thank you. Hi, Ms. Wasala. Can you hear me and see me?
Perfectly clear, thank you.
All right, thank you, Madam Arbitrator. Mr. Jenning, can you hear me and see me?
Perfectly clear. Thank you very much.
Thank you. Ms. Hui Wen, can you hear me and see me?
Yes, I can. Thank you, Winnie.
All right, thank you, Madam Arbitrator. That's the end of our dry run session. Teams and arbitrators, for your information, this meeting is recorded and it will be uploaded by our organizing committee. First and foremost, I would like to congratulate Team 1011 and Team 1010 for making it to the semi-final. We shall proceed by inviting the counsel of the claimant and the respondent to discuss the procedural timetable for today's hearing. Counsel from claimant and respondent, you may have the floor now.
Hi, First Counsel for the claimant. If it's not of inconvenience, may I suggest a certain structure for the submission today? Let's start with the procedural issues with me, and then the First Counsel for the claimant. Then we can commence our rebuttals and rebuttals respectively. Then we can move on the substantive issues with your partner, and then the second respondent, and they will also commence on their rebuttals and rebuttals respectively. Kindly let me know if this structure works for you. Thank you.
Sorry, Clarissa, that question is for Respondents Council, is that correct?
Yes, Madam Arbitrator.
Okay.
Fine by me. We agree.
Thank you, participants. May I request the counsel to stipulate the discussed details in the chat box according to the format which has been sent by my colleague just now. Thank you. Counsel from claimant, may I request you to stipulate the discussed details in the chat box according to the format which has been sent by my colleague just now.
I will write them shortly.
Thank you. Thank you, Counsel from Claimant and Respondent. Teams and arbitrators, before the session begins, I would like to provide a brief of rules. First, each team is allocated maximum 40 minutes to submit their issue. Second, participants, you are kindly reminded to mute your microphone when you are not submitting and are required to turn your camera on at all material times. Ms. Wasala, Mr. Jenning, and Ms. Hui Wen, we have already privately messaged you the score sheet link using the chat box. Could you please click on the link and see if it can direct you to the Google Drive?
Yeah, it's fine for me, working for me.
Thank you, Madam Arbitrator.
It's working for me as well. Thank you very much.
Thank you, Mr. Jenning.
Thank you, Winnie. I'm able to access it.
Thank you, Ms. Hui Wen. Ms. Wasala, Mr. Jenning, and Ms. Hui Wen, you may fill in a score sheet throughout the session, and should you have any inquiries, feel free to seek clarifications from us. That's the end of the briefing of rules. Our session will begin now. Participants and arbitrators, thank you for joining us today and welcome to the semi-final round of the International Commercial Arbitration Moot Championship, ICAMC 2021. We are honored to have Ms. Wasala as the presiding arbitrator, followed by Mr. Jenning and Ms. Hui Wen. The match between 1011 and Team 1010 is now in session. The arbitral tribunal may now progress the arbitral proceedings. Ms. Wasala, Mr. Jenning, and Ms. Hui Wen, you may have the floor.
Thank you. Okay, let's not waste any time. Claimant, please start.
Madam Arbitrator.
Counsel, it seems that your sound is a bit soft. Can you try to adjust your volume?
Excuse me, Madam Arbitrator. I'd like to start first in the discussion with the
I
claimant.
see. All right, noted. Please go ahead then.
Thank you, Madam Arbitrator. Madam President and panel of arbitrators, my name is Clarissa Dawson, counsel for the respondent Zuka Green Energy Limited. Together with me here is my co-counsel Radhashri Kumarasamy and our bench counsel Yu Siu Jing. On behalf of the claimant Future Unix Solar, we have Ms. Priyansi, Ms. Alankrita, and Ms. Ubi. Today, I will be dealing with issue A and my co-counsel will be dealing with issue B and C as stipulated in the moot problem paragraph 26. Before I begin my submissions, may I know if the panel requires a summary of the facts?
Madam Chairperson, I believe you are.
Very well.
A brief summary.
The claimant signed a contract with the respondent to deliver 10,000 photovoltaic panels on the 22nd of August 2020. However, due to a political turmoil, the respondent faced financial difficulties and a shortage of workers. The claimant and respondent then had another oral agreement that the respondent would supply 5,000 photovoltaic panels from the main company and another 5,000 from their second branch. Due to closing of international borders, the respondent supplied the photovoltaic panels 10 days later after the agreed date. The claimant accepted the photovoltaic panels despite the later delivery. However, 6 months later, the claimant brought an action against the respondent. Therefore, both parties resorted to arbitration. That concludes my summary of the facts. I will now begin with my submission. Beginning my submission on the first issue on whether the arbitral tribunal has jurisdiction to resolve the dispute between the parties, the respondent has 2 points to make. Firstly, the law of vows will govern the arbitration agreement. Second, the dispute of the main contract will govern the arbitration agreement. Parties did not expressly stipulate the law governing the arbitration agreement. As a result, in the absence of an express choice of governing law for the arbitration, it is best to refer to the close connection test outlined in the case of Sula Marika versus Anessa Engenharia 2012, where Lord Justice Mobic laid down a three-stage test to determine the governing law of the arbitration agreement. Firstly, is there an express choice of law? Secondly, if not, can a choice be implied? And thirdly, in the absence of a choice, with which law does the arbitration agreement have the closest and most real connection? Since there is no express choice, we shall now look at the second stage of the test, which is the implied choice. The agreed substantive law applicable to the main contract is a strong indicator of the parties' implied choice of the proper law governing the arbitration agreement. Additionally, the reference in the choice of law clause directly preceding the arbitration clause, which can be found in paragraph 9, article 13, sub 1, is a determination of the law applicable to the main contract and is to be interpreted as an implicit choice for the arbitration agreement. In particular, when arbitration agreement is a clause forming part of a main contract, it is reasonable to assume that the parties intend their entire relationship to be governed by the same system of law. According to the Unidua case, Arbitration Court of the Lausanne Chamber of Commerce and Industry, case number 863, it was held the contract between parties did not contain a clear choice of law governing the arbitration agreement. Therefore, the arbitral tribunal found it reasonable to apply Unidua principles rather than a specific domestic law, all the more since these principles are applicable to contracts for services as well as to the sales of goods or the contracts to work. Moving on to my second submission, the respondent submits that the
Sorry, counsel. Could I please interrupt your submissions?
Yes.
I do have a question. You have cited to us the case of Sula Marika. Is this case binding upon the tribunal? And if so, if not, why? Why should we apply or not?
In response towards your question, Madam Arbitrator, this case is not binding towards the tribunal, but it's just persuasive.
So what are the facts in this case of Sula Marika which would allow this tribunal to consider this as a persuasive case authority?
Madam Arbitrator, the test laid out by Lord Justice Mobic is the three-stage test which is to determine the governing law of the arbitration agreement.
Muted. Counsel for the respondent, if I may ask a follow-up question from what my co-arbitrator just asked you. I believe there's a very recent Supreme. Is there a reason why you're adopting the old law of Sula Marika instead of Enka and Chubb? Is there any particular reason? Because if I'm not mistaken, in paragraph 121 to 143 of Enka and Chubb, the Supreme Court has very recently set out new guidelines in what is the law determining the arbitration agreement in the event that parties does not expressly made a reference to such a choice of law in their contract. So what is your position on that?
Mr. Arbitrator, in the case of Enka versus Chubb, they did go for the law of the arbitration agreement that has the most closest and most real connection, which is the seat. However, in our case, regarding the seat, it is to be known that the seat that the parties wanted was a neutral seat. However, according to paragraph 9 of the Moot problem, we did agree on a neutral seat, which was not ignored and it was included in the arbitration agreement. The main purpose we opted for the neutral seat is with the intention of setting aside the award. It was never our intention or choice for the neutral seat to be the law governing the arbitration agreement, as in paragraph 10 of the abandoned discussion, we specify we are not agreeable to fall back on the seat as the governing law.
You may proceed.
Very well. Moving on to my second submission, the respondent submits that the tribunal lacks jurisdiction to resolve the dispute between the parties. Firstly, the arbitration agreement is inapplicable. Panel of arbitrators, according to Article 4.5 of UNIDUA, states contract terms shall be interpreted so as to give effect to all the terms rather than to deprive some of them of effect. It is to be expected that when drafting their contract, parties do not use words to no purpose. With reference to the case of Sandik Asia Private Limited versus Vardaman Promoters, a UNIDUA case, the court pointed out that in order to ascertain the meaning of its individual clauses, the agreement had to be read as a whole, and that individual clauses had to be interpreted so as to give effect to all of them rather than to deprive some of them of effect. In support of this finding, the court referred not only to a number of Indian and English decisions, but also to the UNIDUA principle, citing and quoting specifically Article 4.5. Based on paragraph 19 and 20 of the Moot problem, to 20th March 2021, which was only 10 days. However, both parties had previously agreed in the dispute resolution clause that they shall only refer to arbitration if the dispute cannot be resolved within 30 days. This can be seen in paragraph 9 of the Moot problem. Moreover, in paragraph 23 of the Moot problem, Bow's model law categorizes pre-arbitration clauses as a mandatory requirement to an arbitration. Due to the shorter period of discussion of the dispute, the precondition in the dispute resolution clause is not fulfilled. Hence, the arbitration agreement is inapplicable. To sum up, the law of vows shall govern the arbitration agreement and its interpretation. Furthermore, the tribunal lacks jurisdiction on resolving the dispute between the parties, as vows model law categorizes that pre-arbitration clauses are mandatory. If I may be of no further assistance to this arbitral tribunal, I thank the tribunal for its time and indulgence.
Also, I think we do have questions, but perhaps I'll go after, Madam Chair.
Yes, Council, I do have a question on that, but I'm interested to know if your second chair, your co-counsel, will also be addressing us on this point. Question of the pre-arbitration clauses and the impact that it has on the arbitration agreement.
Madam Arbitrator, my co-counsel will be addressing on the substantive issues of the Moot problem.
I see. In that case, I really do want to explore this point further with you. Am I understanding your proposition correctly? Are you telling us that the failure to fulfill the conditions precedent, the pre-arbitration discussion time frame, renders the arbitration clause invalid?
Yes, Madam Arbitrator.
I see. And what is your authority for this proposition?
According to Article 4.5 of the UNIDUA principles, Madam Arbitrator.
Yes, do elaborate on that, please.
According to Article 4.5 UNIDUA principles, it states that contract terms shall be interpreted so as to give effect to all the terms rather than to deprive some of them of effect. With this article, Madam Arbitrator, we made reference to a case known as a UNIDUA case known as Sandik Asia Private Limited versus Vardaman Promoters Private Limited 2006, where the court pointed out that in order to ascertain the meaning of its individual clauses, the agreement had to be read as whole, and that individual clauses had to be interpreted so as to give effect to all of them rather than to deprive some of them of effect. In support of this finding, the court referred not only to a number of Indian and English decisions, but also this specific Article 4.5 of the UNIDUA, Madam.
Okay, time, I'm afraid, is up. So we should move on to your co-counsel. Is that correct? Is your co-counsel going next?
Yes, Madam Arbitrator. I'm sorry, my apologies, Madam Arbitrator. It isn't my co-counsel, but it's the claimant, the first claimant.
Okay, let's hear from the first claimant. Counsel for the claimant, first lead counsel. Can we hear from you, please?
Madam Arbitrator, respected members of this tribunal, esteemed colleagues, good morning. My name is Priyansi Paudal, and I, along with my co-counsel, Ms. Alankrita Upadhyay, will be representing claimant in this dispute. I will be looking into the procedure of the case, while my co-counsel will be looking into the merits of the dispute. If this tribunal is well versed with the facts of the dispute, can the counsel move to the submissions?
Yes, please go ahead, straight to submissions.
Madam Arbitrator, before my co-counsel addresses the merits, there are some procedural issues which this tribunal must address, and in that frame, the counsel has two submissions. First and foremost, ILIRAD model law is the governing law for the arbitration agreement, and secondly, the tribunal does have the jurisdiction to hear the dispute. In the arena of the governing law for the arbitration agreement, the counsel first and foremost would like to point out to the seat of arbitration, which is ILIRAD, clearly mentioned in the paragraph 9 of the problem, subarticle 2. First and foremost, the counsel would like to refer to the case of Sulamerica, SIA National de Sorgius versus NSA and Hernia, where three principal tests had been set out. That is, whether the parties expressly chose the law of the arbitration agreement. Secondly, whether the parties made an implied choice of the arbitration agreement. And thirdly, in the absence of both, the system of law with which the arbitration agreement has the closest and most real connection with. The counsel believes that there is no express choice of arbitration agreement, neither there is an implied choice of arbitration agreement. Hence, the seat of arbitration, ILIRAD, must be relied upon. In that, the counsel would also like to refer to the two exceptions set out by Enka versus Chubb, which is first and foremost is contracts where applying the principle would mean that there is a significant risk that the arbitration agreement would be ineffective. In that, members of the tribunal, the counsel would like to point out to paragraph 9 of the problem. Is the tribunal with the counsel?
Yes, go ahead.
Respondent was the one who insisted for the seat of arbitration to be neutral, though the preferred choice of my client was DAFL. My client simply accepted the request of the respondent since it is the exclusive supplier for the photovoltaic panels. Furthermore, the state of DAFL suffered a political turmoil from March 2020 to August 2020, which has clearly affected the supply of photovoltaic panels. In this frame, the counsel would also like to refer to the case of C versus D, where the seat of arbitration was given precedence over the governing law of the contract. The counsel just has one question: what is the significance of the seat of arbitration then? What is the purpose of the seat of arbitration? In this frame, the counsel would further like to refer to a case, Navidia Amazonica versus Compania Internacional, where a link was created between lex arbitri and the seat of arbitration. That is, if the parties choose a particular state as the seat of arbitration, the law of that particular state is the law governing the arbitration procedure. Further, for the purpose of an effective contract, one of the leading principles that we all are aware of is the consent. In the instant case, my client had only consented that the underlying contract will be governed by the vows model law. However, in no manner did my client consent that the law applicable in the underlying contract extends to the arbitration agreement in any manner. Further, both the parties have clearly consented to the seat of arbitration to be ILIRAD. So forth, the counsel strongly believes that the law applicable in the arbitration agreement is the ILIRAD model law. Further, the counsel believes that arbitration agreement is independent of the underlying contract. Pointing to Uncitrol model law, Article 23(1), which clearly states that the arbitration clause is an independent agreement of the underlying contract, and the invalidity or non-existence of the main agreement does not directly make the arbitration clause null and void. In this, the council would also like to refer to the words of Judge Stephen Skewell, where he has clearly stated the concept of arbitration, or the independence of the autonomy of the arbitration agreement in itself, where he has stated that the very concept and phrase arbitration agreement itself imports the existence of a separate or at any rate separable agreement, which is or can be divorced from the body of the principal agreement if need be. In this frame, the council would also like to refer to the case of Harbor Assurance versus Kansa General International Assurance.
Counsel?
Yes, Madam Arbitrator.
Okay, I just want to understand where you are taking us with this submission. Are you saying that the principle of autonomy and separability means that we cannot have a different seat and a different law governing the arbitration agreement? Are you saying they definitely must be one and the same?
No, Madam Arbitrator. The council is trying to say that through the principle of separability, the law that is applicable in the underlying contract cannot be applicable in the arbitration agreement in any manner.
Why not? What is your authority for this?
The council has a case called Harbor Assurance versus Kansa General International Assurance Co. Limited, which has clearly mentioned that the substantive contract and the arbitration agreement are two different and distinctive agreements. Further, the council had also referred to the words of Judge Stephen Skewell, where he had mentioned the existence of arbitration agreement to be independent of the underlying contract. Can the council continue? Madam Arbitrator?
Do go ahead. Do proceed.
Thank you, Madam Arbitrator. Therefore, in the arbitration agreement, there is in no express manner in which governing law has been mentioned. So the council strongly believes that the seat of arbitration should be relied upon. Further, the doctrine of separability separates the arbitration agreement and main contract. So the law of vows cannot be applicable in the arbitration agreement in any manner. Can the council continue with the second submission, Madam Arbitrator?
My colleagues may have questions. My esteemed members of the tribunal, I'm sure, will have some burning questions for you at this point.
Yes, I do. I do have a question, and I can also see my co-arbitrator smiling. So I think another question will be coming after mine. So counsel for the claimant, could you please address the arguments that were brought by counsel for the respondent, mainly on the closest and most real connection? So could you please address the tribunal on that element itself? What is your argument on that element? How do you address the arguments from counsel for the respondent on that element? Thank you.
Thank you, Madam Arbitrator, for your question. The case that my fellow respondent has referred to, the case itself has chosen seat of arbitration to be the law governing the arbitration agreement. So the council believes that as the case itself had chosen the seat of arbitration, which in that particular case was London, in this particular case also, the seat of arbitration, which is Elirat, must be chosen. Does the Madam Arbitrator, do you have any more questions?
I think my member of the tribunal might have.
Yes, I have one very short question for you, counsel. So I'll refer to the case of Enka and Chubb again, because currently, after hearing your submission and also the submission from the counsel for the respondent, I'm persuaded to decide that the law governing the arbitration agreement should be similar to the contract, mainly because of the ruling in Enka and Chubb, also because of the reasoning. Because the whole purpose of us having an arbitration agreement is so that it determines the formality, the interpretation of the wordings there. So in Enka and Chubb, the Supreme Court said that we shouldn't have, if there's a governing law for the contract, then that should apply to the arbitration agreement. Only if the governing law for the contract is silent, only we refer to the seat. So if there is a governing law for the contract, the position is very straightforward. In this case, we should adopt the law in vows so that to prevent conflicting policies when it comes to interpretation of contract. So I have not really heard arguments from you to distinguish this position. I'm just going to give you one last chance to try and address the tribunal on this point, because to me, I think the position is quite straightforward and trite. I mean, even though Anchor and Chubb is not binding, but I think the Supreme Court has gone through a great deal to clarify the importance of adopting a similar law for arbitration agreement to the contract if there is a governing law clause for the contract. So what is your stance on this, Counsel?
Thank you, Sir Arbitrator, for your question. The Council had clearly pointed out that the case had two exceptions. The first is contracts where applying the principle would mean that there is a significant risk that the arbitration agreement would be ineffective. Referring to that, the Council had brought forth that the respondent was the one who insisted my client that DAFL, my client had a clear choice about the seat of arbitration and also the governing law, which was DAFL, but the respondent insisted to go with ELIRAD. Further, the state of DAFL suffered a political turmoil, Sir Arbitrator, from March 2020 to August 2020, which has clearly affected the supply of photovoltaic panels.
Thank you, Counsel.
Okay, what's your second point, Counsel?
The Council would like to now move on to the second submission, that is the Tribunal does have the jurisdiction to hear the dispute. In that frame, the Council would like to refer to the case of, the Council would like to refer that the pre-arbitration clause, which my client, Future Unix Solar, was subject to, is not mandatory in nature. First and foremost, referring to the case of Ravindra Kumar Verma versus MSBBTP, where the court held that prior requirements before referring a dispute to the arbitration are only discretionary and not mandatory. Further, the Council would also like to refer to the case of Sulamerica, where it has been said that pre-arbitration clauses are held to be unenforceable owing to uncertainty as laid out.
Before you proceed, now I want to know what your take is on the respondent's lead counsel's submission that let's start by assuming that this pre-arbitration clause is mandatory. Okay, I take your point that you're arguing that it's not, but let's say it is mandatory. Would you agree that the impact of it being mandatory is that the arbitration agreement fails, the arbitration agreement is invalid? What is your take on that?
Arbitrator, could you please repeat your question?
Okay, so assume that the pre-arbitration clause is mandatory. That's the starting point. Starting point is the pre-arbitration clause is mandatory. Does it then follow that breach of the timeline, 10 days instead of 30 days of negotiations, would that render the arbitration agreement invalid?
No, Madam Arbitrator. As the Council has already proved that the law governing the arbitration agreement is ELIRAD model law, the interpretation of pre-arbitration clause will also should also be according to the ELIRAD model law, that is not mandatory. Further, my client, though the law we are referring to here, ELIRAD model law, does not, as the Council has already mentioned, is not interpreted mandatory in the state of ELIRAD. It tried its best efforts to exhaust it had the intention to exhaust the pre-arbitration clause. As there was no consensus between the parties, my client had to refer to this tribunal pursuant to Rule 2 of AIAC. Henceforth, the law governing the arbitration agreement is the seat, that is ELIRAD, and the pre-arbitration clause, which my client has been a subject to, is not mandatory in nature. Thank you. Does the tribunal have any more questions that the Council needs to address?
Council, I do have a question.
Yes,
Do you
Madam
agree with the application of Article 4.5 of the Unidraw Principles as argued by Counsel for the Respondent?
Arbitrator,
Counsel, I'm not too sure whether you've heard my question earlier. My question was, can you please respond to the argument given by Counsel for the Respondent on the application of Article 4.5 of the Unidraw Principles? Are those principles applicable?
sorry, Madam Arbitrator, can the council answer this question later? Oops.
Yeah.
Madam,
Yes, since your time is up, you have an opportunity to address that question shortly. We'll move back to the respondent, second speaker.
Madam Arbitrator, since the first counsel is done with her submissions, as agreed in the beginning that we would go on with procedural rebuttals.
All right, so it's back to you then.
Yes, regarding rebuttals, Madam Arbitrator.
Go ahead.
Very well. Panel of arbitrators, Clarissa Dawson once again, and I will be delivering my rebuttals. The respondents submit that it is the law of the main contract to govern the arbitration agreement, and it is a mandatory requirement to fulfill the 30 days pre-arbitration clause. With reference to a Singapore Court of Appeal case, BCY versus BCZ 2016, the court confirmed the correct position is stated in Sula Marica. In the absence of any indication to the contrary, parties are assumed to have intended the whole of their relationship to be governed by the same system of law. And the neutral inference is that the proper law of the main contract should also govern the arbitration agreement. While seat choice could be a mitigating factor, it would be insufficient in of itself to negate this presumption. The court emphasized that the governing law of the main contract is a strong indicator of the governing law of the arbitration agreement. In particular, when an arbitration agreement is a clause forming part of a main contract, it is reasonable to assume that the parties intend their entire relationship to be governed by the same system of law. If the intention was otherwise, it is not unreasonable to expect them to specifically provide so. Moving on, with reference to the case of Usaha Sama Sendiran Berhad versus Abi Construction Sendiran Berhad 2018, it was held in the High Court judgment that the fulfillment of the precondition to arbitration is mandatory, and before such condition precedent is fulfilled, the arbitrator does not have jurisdiction to hear the matter. That concludes my rebuttals.
Madam Arbitrator, can the claimant move on with the rebuttal?
Okay. Fellow members of the tribunal, do we have any questions for counsel?
Not for me.
I think for me, if Counsel for the claimant could address my earlier question, that would be good. Thank you.
So claimant, you have to address the question posed earlier by the honorable member of the bench.
Thank you, Madam Arbitrator. So as the principle that was referred to clearly stated that contract terms shall be interpreted so as to give effect to all the terms rather than to deprive some of them of effect. But however, the council has already proved that the governing law is LRAD model law, and the interpretation of the pre-arbitration clause should be according to the LRAD model law. Can the council move with rebuttal, Madam Arbitrator? Sir, rebuttal.
Yes, go ahead.
Good morning, everyone. Respected members of the tribunal, esteemed colleagues. This is Priyansi again. And first and foremost, the council would like to point out to the words of our respondent that was both parties resolved to arbitration, which was given while my fellow respondent was giving a summary of facts. This clearly shows the intention of the respondent to also go to the arbitration, to come to this tribunal. Further, the case that my fellow respondent has been referring to, Sula America, the judgment of the case has clearly shown that, has clearly given the seat of the arbitration the precedence over the law of the underlying contract. Thank you. Can the council be of any assistance to the tribunal?
Yes, can you expand on your point? You said that Sula America has clearly established that the seat should be given precedence. Where does it say that?
Could the council have a minute, Madam Arbitrator?
Yes, you can have a few seconds.
Thank you, Madam Arbitrator. So it is referred in, thank you, Madam Arbitrator, for the question. It was referred in paragraph 16.
What does it say? Read it to us.
The court, it said about the three principles or three stage inquiry, that's expressly chose, impliedly chose, and in the absence of both, closest and most real connection. And as in the case, there's no expressly chosen law, they have chosen the seat of arbitration. Like in the particular case, there's a law, Brazilian law, that governs the underlying contract, and the law of London, like a seat of arbitration is London. So they have clearly chosen the seat of arbitration in the in relation to the underlying contract.
Yeah. Just to clarify my question, counsel, I think perhaps I might not have been as clear as I would have liked when I posed the question. You mentioned that Sula America's case stands for the proposition that the seat is to be given precedence or priority over other factors. Am I correct in understanding this submission on your part?
On the contrary, thank you, Madam Arbitrator, for the question. On the contrary, the council is trying to believe that, is trying to prove that the seat of arbitration in this particular case should be given priority over underlying contract.
Okay, but you're not saying that Sula America says that, are you? I'm just trying to be clear on what is your submission and what is stated in the authority you're relying on. I just need a little bit of clarity on that.
The judgment is relying on the judgment of Sula America, where a seat of arbitration of London has been chosen. So
right, okay, nothing further from me.
Thank you very much. Can the council be of any further assistance, tribunal? Thank you very much.
All right, so shall we proceed to the second stage? Let's hear the substantive submissions. Who's next?
It's me, Madam Arbitrator. Panel of arbitrators, my name is Radhasri Kumarasamy, the second counsel for the respondent, Zoka Green Energy. As stated by my co-counsel, I'll be dealing with the second and the third issue. And the respondent's stances are, under the second issue, the oral variation is valid, and under the third issue, there is no breach of obligation. I will now begin with my submission proper. Beginning with the second issue, whether the oral variation made between the respondent and the claimant is invalid, I have two submissions to make. First, the oral variation is valid and there is conformity of the goods. In support of the submission that the varied agreement is valid, I intend to bring this panel's attention to the United Nations Convention on Contracts for the International Sale of Goods, CISG, and UNIDROIT Principles of International Commercial Contracts of 2016. The most pertinent provision under the UNIDROIT Principle of 2016 is Article 2.1.18, which states that a contract in writing that includes a clause requiring any alteration by agreement to be in a certain form cannot be amended in any other way unless the other party fairly relied on that conduct. This is similar to Article 29 of the CISG. By drawing a conclusion from the article I had mentioned, I would like to emphasize that the claimant was aware that the respondent was facing serious financial constraints as the respondent's business was badly affected by the political turmoil. Therefore, it was truly essential to vary the initial contract because it is obviously of no use to the claimant to stick with only 5,000 photovoltaic panels from the first branch. Consequently, what the respondent did was reasonable as it was not only for their own benefit, but for the claimant as well. The claimant might have been hesitant to accept the new contractual term as any reasonable person would be reluctant to depart from something settled. However, in this given situation, it was meaningless for the claimant to hope that the initial contract could be maintained. Owing to the existing challenges, both sides reached an agreement but agreed not to put it in writing. However, since the claimant and respondent had agreed, the respondent relied on the oral agreement and made arrangements to provide 5,000 photovoltaic panels from the second branch. It would be unlikely for the claimant to obtain all 10,000 photovoltaic panels and begin the operation of the ultra-solar project if the respondent had not relied. Therefore, the oral variation is valid. The crux of this point, panel of arbitrators, is that the written contract should be ignored in this circumstance. It is crucial to focus on the oral agreement because that is exactly when the respondent had relied on the oral variation to supply the 10,000 photovoltaic panels. It is thus a valid agreement. The respondent's second submission for the second issue is that there is conformity of the goods. The most relevant provision under the CISG is Article 35. Article 35, Section 1 states that a seller must provide goods in the quantity, quality, and description specified in the contract. Among the requirements stated for the successful bidder was that the solar panel must be equipped with the latest technology, photovoltaic panels, and that's exactly the reason local council had recommended respondent to the claimant. This is due to the fact that the respondent is the exclusive provider of the photovoltaic panels of the specific design which was needed. Therefore, in order to satisfy the requirements of the photovoltaic panels needed by the local council, I would like to bring paragraph 7 of the Moot problem to the attention of the panel of arbitrators that as per the certificate, regular inspection must be done every week to ensure the effectiveness of the photovoltaic panels. On top of that, it was also informed by the respondent that the photovoltaic panels' heat resistance is up to 40 degrees Celsius. And in the case of extreme heat, it would only reduce 5% of its efficiency. So it is the responsibility of the claimant to carry out the inspection as instructed. Furthermore, since 95% of the photovoltaic panels could function effectively, the 5% of the malfunctioning photovoltaic panels can be replaced. There is no need to terminate the contract as 5% is a very small quantity. During September and October, before El Nino commenced and claimant did their regular inspections, they were El Nino season happened, then only there were malfunctioning of panels due to overheating, meaning to say that the overheating only occurred after El Nino season has happened, and since respondents' photovoltaic panels meet up to the required specification, it is suffice to say that the overheating of the panels are caused by the El Nino season. In fact, Claimant only discovered this issue 5 months later, where El Nino season had already happened. Had Claimant carried out the inspection regularly every week during the 3rd and the 4th month, they would have discovered this issue earlier and come up with possible solutions to overcome this issue at an earlier stage. Therefore, the respondent cannot be held responsible for the recklessness of the claimant. The 10,000 photovoltaic panels are conforming to the contract. Moving on to my 3rd issue, whether the respondent breached its obligation to deliver 10,000 photovoltaic panels later than the agreed date, I have one submission to make. The respondent's submission for the 3rd issue is that the obligation has been initially agreed. In accordance to that, reference will be made to the case of Sim Chio Huat and Wong Tut Fui, where Federal Justice Saleh Abbas held that if in contract in which time is of the essence, a party fails to perform it by the stipulated time, the innocent party has the right either to rescind the contract or treat it as still subsisting. If it treats it either expressly or by conduct as still conducting, the contract exists but time ceases to be of the essence and becomes at large. Consequently, as stated by Federal Justice Saleh Abbas, the claimant's behavior while waiting for the respondent to deliver the 10,000 photovoltaic panels demonstrated that the claimant waived the right to terminate the contract for late delivery. The claimant had the option of refusing to accept the photovoltaic panels when they were delivered on 1st September 2020, but instead accepted the 10,000 photovoltaic panels. The most relevant provision under the Unit 2 is Article 6.1.1, Section 1, which states that a duty must be performed if a period is fixed or determined from the contract at that time. In the initial contract, the respondent was made aware of the importance of the delivery date, which the respondent had agreed to supply 10,000 photovoltaic panels to the claimant on the 22nd August 2020. However, it is worth noting that the original contract is no longer useful because it has been modified by all parties. The new contractual terms that were settled upon are now in force. So although time was previously made of the essence, the issue of timing was never addressed in the oral agreement at all. Furthermore, the Laos government closing the international borders is very likely to experience a delay in the delivery of the photovoltaic panels. In addition to the other problems the respondent is facing, since there is no other way the respondent will supply them on time. International borders were closed until late August, as illustrated in the Moot clarification number 17. Despite the challenges, the respondent was able to successfully deliver and install the 10,000 photovoltaic panels on the following day, 1st September 2020. Even though it was 10 days later than the agreed date, it was completed within a fair amount of time. Previously, when the respondent decided to supply 10,000 photovoltaic panels, it did so directly from the respondent. However, this is no longer the case since half of the photovoltaic panels are supplied from the second branch, and any delay may have resulted from them. The crux of this case, panel of arbitrators, is that the claimant's action must be considered to have elected to regard the contract is still in effect. The claimant had obtained the 10,000 photovoltaic panels in accordance with the contract. Therefore, despite the fact that the delivery occurred 10 days after the originally agreed date, the respondent had fulfilled its duty. Before I conclude my submission, may I know if there is any question from the tribunal that I may address?
Counsel, can you clarify for us what you're actually asking us to do? What remedy do you seek from us?
Madam Arbitrator, the claimant is trying to terminate the contract. Therefore, they are seeking the remedies. But we are trying to prove that there is no need to terminate the contract because the malfunctioning photovoltaic panels can be replaced and the oral variation is valid.
Okay, so what do you want from us? What findings do you expect us to make?
The oral variation is valid, Madam Arbitrator, because there was a reliance.
Okay, so I'm a bit curious because I looked at your written submissions. I have had the opportunity to peruse your written submissions, and I noticed that one of the findings that you're seeking is a declaration that the arbitration agreement is invalid. Do you stand by that? Are you seeking that declaration?
Madam Arbitrator, is it the memorandum?
Yes, that's right, your memorial.
Madam Arbitrator, I would like to inform that we had depart from the memorandum because the more research we did, we found there are loopholes in our arguments. So that is why we actually fixed our argument in this oral hearing.
Oh, I see. So you're departing from your written submissions.
Yes, Madam Arbitrator, because
yes, do you clarify for us where you are departing from it?
My apologies, Madam Arbitrator, because as per the rules and regulation, the participants are allowed to depart from the memorandum. So there are certain loopholes in the oral variation previously. It has been a long time since we actually submitted the memorandum, but this is the recent argument that we had put forward.
Okay.
And we believe it is a strong point.
Okay, so you're no longer, perhaps I should address this question to your co-counsel again, since she was the one submitting on this point. My question is, are you still asking us to uphold the arbitration? Are you still asking us to find that the arbitration agreement is invalid?
Yes.
Or are you starting from that?
Yeah, yes, Madam Arbitrator.
You're still asking us to do that?
Yes, Madam Arbitrator.
Okay, so assuming we find that it's invalid, then how are we to be persuaded to make findings on the substantive merits? Could you just explain that for us?
Madam Arbitrator, the respondent is trying to address that the tribunal lacks jurisdiction on deciding the substantive merits because of the invalid arbitration agreement.
And therefore, questions from the tribunal on this?
I do have a question. I have two questions actually. My first question is, was there any certificate of compliance issued for the 5,000 batches from the 5,000 panels from the second branch? Number two would be, in the oral variation as discussed, where does it say or state in the moot problem of clarification that there was a variation as to delivery, date of delivery, because I could not locate it. So I would appreciate some assistance from counsel.
To answer your question, Madam Arbitrator, the first question that you imposed, whether there is whether the oral variation, the delivery date, right? So there is no matter of discussing the date of delivery in the oral agreement, Madam Arbitrator. And if it is important, then the claimant could have brought the issue of time is of the essence during the oral agreement, but they didn't brought up the matter at all.
Because counsel, based on the facts of this case, it would seem that the claimant, being concerned that the respondent could not deliver on time due to the political turmoil, started to call the respondent, your client, and finally, after, from what I read of the facts, after some assurance from your client that the second batch, that the other 5,000 panels could come through to meet the deadline, that the claimant agreed. So I have read the facts this way, that the claimant has never waived the delivery date and it has always been the same date. It's just that the claimant agreed for the 5,000 panels to come from another branch.
Yes, that's true, Madam Arbitrator. What I mean is, from my argument, they had waited 10 days to accept the photovoltaic panels. They had made the payment and they had commenced the ultra solar project. So the conduct of the claimant shows that they had waived the right to terminate the contract because they had used the photovoltaic panels without any complaints for 5 months. And only after they get to know the photovoltaic panels is not up to their standard, they brought a claim for late delivery as well. So it is unjustifiable because the respondent had discharged their performance. It has been 5 months. Did I answer your question, Madam Arbitrator?
So essentially you're saying the conduct of the claimant waived the entire breach when it comes to late delivery because they have accepted that late delivery. Is that right, counsel?
Yes. Yes, Madam Arbitrator.
Okay, how about my first question that I asked you earlier on the certificate of compliance? Because that would tie in very closely to your Article 35 sub 1 of the CISG, right, on the quality and description of the goods.
Yes, Madam Arbitrator. Could you repeat the question, please?
Was there any certificate of compliance issued for the 5,000 panels from the second branch?
Stating the specification of the photovoltaic panels included the 5,000 photovoltaic panels from the second branch.
Could you please point to which paragraph of the moot problem?
Sure, Madam Arbitrator. May I have a moment?
Sure, counsel.
Much obliged. Madam Arbitrator, to answer your question, if I may refer you to number 11 of the moot problem clarification, it stated that the certificate given by the respondent included the assurance that the panels from the second branch also met the requirements of the local council.
But counsel, that's just an assurance. There is no separate certificate that was issued, right?
No, Madam Arbitrator, there was no separate certificate, but it included the specification. Therefore, my client respondent had give the photovoltaic panels that met the requirements of the local council.
Okay, but your argument would be, even if there is no certificate issued, it wouldn't have mattered, correct? Because there was the El Nino incident that has caused the overheating, correct? It was not of the quality of the product itself. Is that right, counsel?
Yes, Madam Arbitrator. Yes, Madam Arbitrator.
All right, thank you.
Is there any questions I could address?
Sorry, just one quick question from my end. I'll try to keep it
sure,
short.
Mr. Arbitrator.
I'm not sure about what my fellow arbitrators think, but I personally thought that, for each of the arguments that you have put forth, the factual arguments that you have used to support your main argument, your main submissions are pretty strong. And I think you have addressed some of the doubts that I have, except for the point that my co-arbitrator Hui Wen just raised earlier on date of delivery. But apart from that, I think you did quite well in terms of the facts. So I just want you to focus on assisting me with the doubt that I have on the policy of the law on the no oral modification clause here. Because as you know, in practice, arbitral awards can be challenged on question of law. So I think as arbitrators, we need to be mindful of your submission. Because to quote your word, you mentioned that the written contract here should be circumvented. and we should instead focus on the oral contract.
Yes.
I'm giving you the benefit of the doubt that you're only referring to the clause itself, that we should sidestep and circumvent the clause. The issue here is this. Are you saying that every time there is a detrimental reliance on an oral term, then we should not look at the written term? That's my question. The reason why I'm asking this is because, from my understanding, the whole purpose of a no oral modification clause is to cater for situations like this, when there are duress, when there are times where I need to make when business parties need to make a decision on the spot. They want to make sure that parties have thought through it properly and pen things down in writing before I enter into a modified contract. Now, in this case, because of the political turmoil, the claimant might be pushed, or rather forced, coerced to enter into this contract just so to make sure that you, the respondent, can deliver 10,000 photovoltaic panels. But in actual fact, you did not deliver 10,000 photovoltaic panels in accordance to what you initially agreed to submit from your initial branch. So I'm just mindful of your thoughts on this, on the policy. So, every time, is it your position that whenever there is an oral term where parties have acted on it and has suffered detrimental reliance, suffered detriment on it, then we should sidestep the written contract? Because that is a very, very far-fetched argument to me at this point. And in paragraph 31 of your written submission, you cited the case of advertising and MWB. That's the UK Supreme Court case. And I believe that case is very clear that even though you can rely on estoppel, but that doesn't mean you can sidestep a written contract term. Because if you were to be able to sidestep this no oral modification clause, it would essentially render this kind of clauses ineffective, or rather you'll be handing a death letter. So what's the purpose of us having this clause in the first place? So I'm just mindful of this policy here. If you could address me on that. Thank you.
Sure, Mr. Arbitrator. In regards to your first question, the non-oral modification clause, we are not against the non-oral modification clause, but looking at the given situation, the respondent had relied on the oral variation. Therefore, it was necessary to vary the original contract. So in that moment, if they did not vary the original contract, then there will be consequences faced by the claimant. So my client is arguing that it is necessary in that moment, it is urgent to vary the contract. And to your second question, whether there is a pressure, the claimant reluctantly agreed, we agree, but the respondent did not push the claimant. The claimant had a choice to ask for an extension of time, but they did not. So there is no claim for pressure. And your third question, rock advertising. Yes, we had used rock advertising previously in our memorandum, but it is not the Lord Sumption's reasoning, it is Lord Briggs' reasoning. So according to Lord Briggs, as I had mentioned in my previous answer to your question, if there is a necessary implication, then we could dispense the non-oral modification clause. So that is my argument, Mr. Arbitrator.
Thank you very much. That's very helpful.
Much obliged. Is there any other questions that I could assist?
No, that's fine. We'll proceed to the last counsel.
Sure. Before that, I'll conclude my submission, Madam Arbitrator.
I think you're out of time. Let me just check with the bailiff. Bailiff, are we out of time?
Yes, the time is up for the counsel.
Okay, so we will proceed straight to the final.
Madam Arbitrator, if you don't mind, may I request for an extension of 1 minute?
Okay, you can have 1 minute.
Much obliged, Madam Arbitrator. To conclude, the oral variation made between the claimant and the respondent is valid, and the respondent had not breached its obligation by failing to deliver the 10,000 photovoltaic panels on the agreed date. If I may be of no further assistance to the arbitral tribunal, I thank the tribunal for the time and indulgence. Much obliged.
Okay, next counsel. Final counsel. Alankrita Upadhyaya.
Yes, Madam Arbitrator. Honorable members of the tribunal, esteemed colleagues, greetings. So as my co-counsel clearly specified as to how this tribunal would have jurisdiction to hear the dispute, the council now would like to move towards the merits of the case. However, before heading towards anything else, the Council would like to request the Tribunal to refer to paragraph 1, paragraph 5, and paragraph 17 of the problem. My client, Future Unix Solar, is one of the biggest solar energy providers in the world. My client specializes in planning, financing, constructing, and maintaining solar power plants all around the world. And as a matter of fact, my client was awarded with the Ultra Solar project just because of my client's ability to hold 20 solar power plants all around the world. However, as we refer to paragraph 17 of the problem, my client's reputation is being questioned in a state where it actually operates, and the Council who actually gave the Ultra Solar project agreement has been threatening my client with no fault of my client being one. In order to prove the innocence of my client, the Council has two submissions, where firstly, the Council would prove that the oral variation made to receive 5,000 photovoltaic panels from the Respondent's second branch Viagari is invalid, and that the Respondent is not in breach of Respondent is in breach of its obligation to deliver 10,000 photovoltaic panels on 1st September 2020, which is later than the agreed date. The Council has two interrelating arguments with regards to her first submission, where firstly the Council puts forward that the Tribunal should find NM clauses to be effective when the parties have agreed for an oral variation, and that even if the Tribunal finds an informal variation to be effective, the goods delivered did not fulfill the purpose of the contract. Members of the Tribunal, the Council first would like to state the principle of pacta sunt servanda, which provides the sanctity of the contract, where every party should be obliged to fulfill their obligations under the contract. Referring to paragraph 11 of the problem, Article 1 General of the Ultra Solar Project Agreement, it clearly provides that all variation must be agreed, set out in writing, and signed on behalf of both the parties. Now, as we know, the sentences used in Article 1 General of the Ultra Solar Project Agreement forbids any oral modifications to be effective. And as to why NM clauses are important, or why non-oral modification clauses are important, the Council would like to state the case Rock Advertising Limited versus MW Business Exchange Centers, where Lord Sumpton provided that NM clauses must be effective as it reduces misunderstandings that may arise during an oral variation. Further, in Globe Motors Inc. versus TRW Electric Steering Limited, it was held that the existence of an NM clause would be a factor in determining whether the parties agreed to an binding variation. Therefore, members of the Tribunal, it is actually extraordinary to just ignore the terms of a contract. And further, my co-counsel, the Respondent's Counsel clearly states the principle of Unidroit and CISG, where she provided that NM clauses shall not be effective when there is reasonable reliance. Now, again stating the case of Rock Advertising Limited versus MWB, Lord Sumption provided that when there is such a representation of when there is NM clauses present in a contract, when there is NM clauses present in a contract, it is hard to see how the recipient can reasonably rely on an informal representation in circumstances as such. Members of the Tribunal, it was very unreasonable for the Respondent to rely on the claimant's conduct, because as a matter of fact, we know that the claimant operates in a different state and the Respondent operates in a different state. So such circumstances could have been foreseeable as a matter of fact, due to which it was very unreasonable for the Respondent to rely on the oral variation despite having an NOM clause. Further, the Council now would like to move towards her second argument of the first submission, which provides that even if this Tribunal would find the NM clauses to be ineffective and find the oral variation to be effective, the goods actually did not fulfill the purpose of the contract. Members of the Tribunal, the Council would like to state the Article 35 of the CISG, which provides that the seller is in obligation to deliver the goods that conform to the quality of the product under the contract. If the contract requires the seller to deliver the goods that comply with a particular standard, the seller is in breach of contract if the goods do not comply with the contractual specified standard. Further, Article 35(2)(b) of the CISG provides that goods are non-conforming if they are unfit for the particular purpose of the contract made known to the seller at the time of the conclusion of the contract. Members of the tribunal, my client clearly specified in the certificate of specifications, actually the express warranty that was provided by the respondent in paragraph 7 of the problem regarding the certificate of specification. It clearly provided all the conditions that was required by the DAFO local council would be fulfilled. Now, what is the purpose of the DAFO local council? Was to generate electricity to 91,000 homes in Reni. And as provided in the certificate of specification, the respondent clearly provided that only 5% of the efficiency would decrease when the temperature would increase up to 40 degrees centigrade. But just because the temperature increased up to 41 degrees centigrade, not just 5% members of the tribunal, 60% of the efficiency of the photovoltaic panels decreased. Now, the respondent had made the new design, the cylindrical design, which was required by my claimant. My client had...
Counsel?
Yes, yes, Madam Arbitrator.
I have a question for you.
Yes.
Why did it take your client 5 months to discover the malfunction?
Thank you so much, Madam Arbitrator. So in the first 2 months, the El Nino season didn't happen, Madam Arbitrator, due to which no issues were occurred. However, the El Nino season happened in the third month, which is the November, and since the maintenance was carried out after the 5 months of the operation, the issue was discovered, Madam Arbitrator.
So, would you agree that the respondent cannot be faulted for the El Nino season?
Indeed. Sorry, madam, please continue. I'm so sorry.
No, go ahead. I'm just wondering how we are ascribing blame to the respondent for the exceptionally inclement weather.
Indeed, Madam Arbitrator, the Council agrees to the fact that the El Nino season was unprecedented, but the certificate of specifications clearly identify that even if the temperature would increase up to 40 above 40 degrees centigrade, the efficiency would just decrease by 5%, and the efficiency decreased by 60% if we refer to paragraph 15 of the problem, Madam Arbitrator.
Thank you. You've answered my question.
Thank you so much. So as provided, the seller, the particular purpose of the contract was to generate 350 megawatt of electricity on a daily basis. However, only 140 megawatt of electricity was generated, which was provided as the expert. Therefore, Madam Arbitrator, the Council again would like to state the principle of caveat venditor, where the seller should be aware about the goods it's delivering. Now, we can agree to the fact that the seller is an exclusive supplier of the photovoltaic panels, due to which my client would have been less aware of the specific design of the photovoltaic panels, although my client had done due diligence in the matter of fact. However, so since the seller was the exclusive supplier, had known about the purpose of the contract, had known what type of quality it should have done, it should have provided, the goods delivered were of deferred quality, due to which the particular purpose of the contract wasn't fulfilled, and my client wasn't able to fulfill the conditions as provided by the DAFO local council. Therefore, the council submits that the goods did not fulfill the purpose of the contract. Further, my co-counsel clearly specified about the inspection. However, the council would like to define inspection as per the ICO certified International Organization for Standardization, which provides that an inspection is an examination of a product, process, service, or installation on the determination of quality with specific requirements. It clearly provides us inspection. What could an inspection do was just look at it. However, we cannot deny the fact that the goods were of deferred quality. The goods were defective. The inspection could have analyzed it, could have looked at it. However, the goods were of deferred quality. So the respondent claiming that it being the exclusive supplier and asking the inspection just because of an issue, everything was at our fault, is it doesn't come in that stances, members of the tribunal. So before the council moves towards her second submission, is there anything the council can assist the tribunal with?
I shall leave it to my fellow arbitrators for questions.
No questions from my end at the moment. Hui-Wen?
Yes, I do have a question. It's regarding the certificate. As pointed out by the respondent earlier to the clarification, there was no certificate issued for the second batch, the batch from the second branch, but there was assurance. To what extent did your client rely on the assurance?
Thank you so much, Madam Arbitrator, for your question. So yes, my client relied on the, since the respondent is the leading solar panel supplier, my client, the certificate of specification was provided for the 5,000 goods, but since the respondent claimed that it was its second branch, my client, however, relied on the certificate of specifications itself. Yes, Madam Arbitrator.
Thank you.
Thank you. Now, the council would like to move towards a second submission, where the council submits that the respondent is in breach of its obligation to deliver 10,000 photovoltaic panels on 1st September 2020, which is later than the agreed date. With regards to the second submission, the council has two interrelatable arguments, where firstly, the council would prove that the respondent has violated the sanctity of the contract by delaying the delivery of 10,000 photovoltaic panels. And secondly, the council believes that a tribunal should not excuse the respondent for the delay. Members of the tribunal, the co-counsel from the respondent clearly specified that delaying the delivery was not acted as non-performance. However, answering this question, the Art Council would like to state Article 7.1.1 of UNIDROIT, which clearly specifies that non-performance is defined as a failure to party to perform any of its obligations under the contract, including defective performance or late performance. Members of the tribunal, time is clearly the essence of the contract as provided in Hartley versus Hyman. Further, in the case of Bose versus Chan, the House of Lords held that the stipulation of a time to be the essence. My client, as provided in paragraph 6 of the problem, clearly specified the delivery date is very important, which is 22nd August 2020, as it would impair my client's ability to work and perform under the obligations of the contract with the Dhaka local council. The delivery date was made very clear to the respondent. However, the respondent did not act to the delivery and delayed the delivery of the photovoltaic panels. Further, the council would like to state the case of Lombard North Central Lake versus Butterworth, which provides that the consequence is that a delay in performance is treated as going to the root of the contract without regard to the magnitude of the breach. It is the time for the performance of a contract or the time of delivery is fixed. It cannot be extended by the unilateral act of the party as provided in Dinkarai Lalit Kumar versus Sukhadayal Ramivilas. Members of the tribunal, the respondent unilaterally acted and delayed the delivery of the contract, which cannot be taken into account as time is the essence of the contract, and it is non-performance if the seller is in an obligation to provide the contract in the time and it did not. Members of the tribunal, now the council would like to move towards her second argument of the second submission, which provides that the failure to perform their contractual obligations cannot be exempted. In this case, members of the tribunal, the respondent has contended that a delay in delivery was due to, firstly, the counsel from the respondent clearly specified the delay in delivery was due to the respondent was facing some financial crisis and that the vow's political conduct. The financial crisis, however, cannot be taken into account because it is something that a company must do, and that even if the company is facing a difficult situation, it cannot just act in a way that would repudiate the terms of the contract. Further, members of the tribunal, the respondent has stated the vow's political conduct, the enclosing of international borders, to be an effect for the delay. However, there are no force majeure clause in the arbitration agreement. Further, tribunals, however, have rarely enforced force majeure clauses unless a specific impediment is defined in the contract. Further, only if the force majeure clause specifically includes the event that actually prevents a party's performance, that party will be excused. Therefore, no force majeure clauses at the first hand, and that the specific impediment was not defined, due to which this the contention of the respondent cannot be excused. Further, members of the tribunal, even if we consider the impediment to be one of the excuses, the respondent cannot be excused as the respondent did not provide notice to the claimant regarding the vow's political conduct. When the respondent is itself claiming that due to the unforeseeable circumstances, the respondent could not have presumed the delay, how can the respondent presume for the claimant to know about the delay because of the vow's political conduct? As provided, tribunals have denied to claim force majeure clauses for failing to provide timely notice. It has been held, members of the tribunal, moreover, the council has clearly stated that since my client has accepted the goods, the delay should not be taken into account. However, moreover, at common law, it is a general law that a vendee may accept the goods and bring an action for damages he may have actually suffered in consequence of late delivery. It is not by accepting the late delivery waive any claim he may have damages arising for the delay. Further, it is well settled that the acceptance of delayed performance under the contract is not inconsistent with the right to demand damages for the delay and hence is not in itself a waiver. The claim of the respondent where it delayed the delivery, it did not even provide the notice as it should, considering Article 7.1.7 Part 3 of the unit right. No notice was provided to my client, due to which the respondent cannot be exempted for the reasoning it's providing for the delay. Members of the tribunal, is there any question the council can assist the tribunal with before the council concludes?
None from
Lewin, do you have any questions? Because otherwise, I thought of getting council to address one small question that I have for her first submission on the validity of the clause.
I think you could ask your question first, Mr. Co-Arbitrator. Thank you.
So, council, I just wanted you to address the tribunal on if the respondent had not supplied the second batch of the photovoltaic panels, you would not be able to uphold your promise, or rather the contract with the local council, isn't it? So, yeah, what is your stance on that?
Members of the tribunal, the council would like to submit that if the council submits that if the only 5,000 batch was provided, the other 5,000 batch was not provided, then it would have affected the contract. However, in this case, members of the tribunal, if after that oral variation, the goods, if fulfill the purpose of the contract, the council would not have been making this statement. The goods did not fulfill the purpose of the contract. The goods were of deferred quality, due to which if the 5,000 photovoltaic panels that was brought from the respondent second batch February fulfill the purpose of the contract, and that if the malfunction did not happen, and that if the efficiency as provided in the certificate of specifications, if everything was fulfilled, the council would not have brought this claim. However, since it did not fulfill, the council is bringing this claim. Is Mr. Arbitrator clear, or shall I more clarify? Shall the council clarify more?
No, it's okay. I take note of your point.
Yes. Thank you. Shall the council conclude, or is there any questions the council can make sure of with the members of the tribunal?
I think none from me. None from me, council. Thank you.
Go ahead with your conclusion in that case.
Thank you so much, members of the tribunal. So as the council concludes, the council would like to request the tribunal to find the respondent liable for non-performance, and also for the damages, and like to claim damages for non-performance, and also would like to find the respondent liable for damages as it did not provide notice as per to Article 7.1.7 of the unit right. Having said that, the council now would like to request the tribunal to find that this tribunal would have jurisdiction to hear the dispute. the oral variation made to receive 5,000 photovoltaic panels from the respondent's second branch Vaiguri is invalid, as it did not even fulfill the purpose of the contract and when the seller was in a duty to fulfill the purpose of the contract, and that the respondent is in breach of its obligation to deliver 10,000 photovoltaic panels on 1st September 2020, which is later than the agreed date, as no notice was provided, and that no notice was provided, and that time is the essence of the contract. Thank you so much.
Thank you. Okay, well, I suppose we are now done with the oral presentations, and it is time for, well, we've got a minute to go for feedback. Let's start with feedback straight away, because
My apologies, Madam Arbitrator. We still have rebuttals, censor rebuttals.
Oh, is that right?
Yes.
Okay, all right. Well, let's make short work of that then. Go for it.
Sure.
Who's next?
It's me, Madam Arbitrator.
Go ahead.
Panel of arbitrators, Radhasri Kumarasamy once again, and I'll be delivering few rebuttals. According to Article 4.1 of the Unidua Principle, which states the intention of the parties, Section 1 provides a contract shall be interpreted according to the common intention of the parties. This reluctance masks the true intention of the claimant, which is to fulfill its obligation to the state of Dafal. Corresponding to that true intention, the respondent has effectively varied the agreement so that the claimant will receive 10,000 photovoltaic panels. It is crucial to focus on the oral agreement because that is where the true intention of the parties lie. My second point is, according to Article 1.8, it is an inconsistent behavior. A party cannot act inconsistently with an understanding it has caused the other party to have upon and which that the other party has reasonably relied. The act of the claimant relying on the non-oral modification clause after using the photovoltaic panels after 5 months without any complaints is acting inconsistent and contrary to the principle of good faith. And in regards to the rock advertising case, which claimant had mentioned, as per Lord Brake's view in the case of rock advertising and MWB, the non-oral modification clause could be dispensed with by necessary implication, as I had mentioned previously, in situations of urgent performance where there would be no time to comply with the formality requirement. Therefore, in this given situation, it was necessary to vary the contract without waiting for any further delay. We agree that the non-oral modification clause provides certainty, but it is the expense of practicality in this given situation. Moving on to my next point is the claimant failed to carry out the inspection. As illustrated in the Moot clarification number 16, inspection must be done every week. However, inspection was only done on a regular basis for the first 2 months, which is September and October. The respondent cannot be held accountable for the claimant's failure to carry out the examination in the months following October because it is the instruction have been followed, the efficiency of the solar panels would not have been diminished by so much in the first place. And in regards to the malfunctioning photovoltaic panels, we agree there is 200 more panels which are in defects than the expected amount. But I would like to refer the panel's attention to number 29 of the Moot problem clarification, that a replacement of the photovoltaic panels can be made. There is no necessity to terminate the contract. If it goes to the root of the contract, then the claimant shouldn't accept the panels without any complaint. The conduct is very unfair because the respondent had discharged their performance. I would like to refer the panel to paragraph 28 of the Moot problem clarification, as it was stated that the international borders were closed in early April until late August, which is when the time of delivery of the photovoltaic panels took place. The parties did not foresee that the political crisis would last 5 months. Therefore, this is in accordance with Article 6.2.2a Unidua Principles of 2016, which states about hardship. Besides that, the failure of the Zoka Green Energy Limited to deliver the photovoltaic panels on 22nd August 2020 was due to an unforeseen circumstance that was beyond the control of Zoka Green Energy. The extended period of the political crisis could not have reasonably been taken into account by Zoka Green Energy at the time the contract was concluded. Therefore, the closing of the international borders is a hardship, and this is in accordance with Article 6.2.2 B and C of the UNIDOA Principles of 2016. Therefore, panel of arbitrators, this constitutes a case of hardship since the closing of international borders involves was not foreseeable or in the scope of the control of Zoka Green Energy. That's all from me.
Counsel, I do have a question.
Yes, Madam Arbitrator.
Sorry, Counsel, I do have a question.
Yes, Madam Arbitrator.
Okay, Counsel, my question is regarding the argument that you have put forward that is against good faith. Could you please point to the tribunal where in the contract does it say that there's a duty of good faith? Or how would the duty of good faith arise in this case? Is there any governing law provision for this? Thank you.
Madam Arbitrator, there is no duty of good faith, but however, the fact that they had used the photovoltaic panels and later claiming for the late delivery is very unfair.
Would any provisions in the UNIDROIT principles that you have been citing be of assistance when it comes to the good faith argument you put forward?
Yes, Madam Arbitrator, it is Article 1.8, which states that a party cannot act inconsistent because they have to act in good faith.
That's all from me. Thank you.
Is there any other questions that I may address?
So nothing further. Let's hear the other side, your counterparty.
Thank you.
Thank you so much. So the council now would like to move towards its rebuttals. Rebuttals, where firstly, the council clearly specified that the common intention could be determined with the oral variation that was done, but the council believes that the common intention couldn't have to be determined because there was an NOM clause. Thus, the reasonable party test shall be taken, where the reasonable party is a person who has a prudent foresight. Therefore, as provided in the Lord's Assumption view, the council that reviewed earlier, that reasonable party in the existence of an NOM clause couldn't have just relied on an oral variation. Secondly, members of the tribunal, the council would like to again state the fact that the goods did not fulfill the purpose of the contract at any case. The respondent was in a duty to deliver goods that were of perfect quality as provided in Article 35 of the CISU as well. However, the goods were not of deferred quality, and due to which such an issue came up. Further, the council would like to state the clarifications on moot problem that my co-counsel stated regarding the Solar Energy Research Panel 28, paragraph 28, which provided that only even during the El Nino season, not just the express warranty that was provided in paragraph 7, only 300 of the photovoltaic panels could have malfunctioned, considering 3% of 10,000. However, 500 of the photovoltaic panels malfunctioned, which clearly proves that the respondent did not fulfill its obligations under the contract and did not provide the perfect good. Further, members of the tribunal, the respondent could have done anything else. As provided, the council would like to request the tribunal to refer to paragraph 8 of the problem, which provides that the state of Vaigari is a different state, where the political turmoil was just in a state of chaos. 5,000 photovoltaic panels was to be received from the state of Vaigari. The respondent did not even provide notice, and if the respondent was trying to act on its obligations under the contract, the respondent could have easily sent the 5,000 photovoltaic panels from the state of Vaigari, which was not done by the respondent. Therefore, members of the tribunal, the council submits that my client should be found innocent and the respondent shall be liable for damages. Having said that, the council would like to conclude. Is there any questions the council?
No questions from me. Thank you,
address?
council.
No questions from me.
Thank you.
None from me as well. Thank you, Council.
Excellent. So thank you, everybody. You've done very well today. We now move on into the feedback session. And I'm going to perhaps invite Hui Wen first with her remarks.
Thank you, Madam Presiding Arbitrator. All right, I'd just like to congratulate both teams for making it thus far to the semi-finals. Well done, really. I am so proud of both teams, councils and also researchers for putting in the work to get to this stage. Congratulations. Okay, I have feedback. I do have general feedback, which I think would apply to everyone. The first point from me would be addressing the tribunal. If the presiding arbitrator is female, you would have to address her as Madam Presiding Arbitrator, not just in your submissions, but also in your communications with her. So for example, when you greet, if you answer a question, if you say thank you for an extension, the same address would have to stay throughout. So you have to familiarize yourself with this, because increasingly there are more and more female arbitrators who are appointed, and more female presiding arbitrators who are appointed. So it would do you good if you could ingrain it in yourself to have Madam Presiding Arbitrator in your form of address to the tribunal at all times. If you can't remember that, then it's best to just say members of the tribunal, even if it's responding to a question. But I don't think that would be a very good solution moving forward. It's best to just address specifically Madam Presiding Arbitrator. If it's not a presiding arbitrator, then it's Madam Arbitrator. If it's a gentleman, then Mr. Arbitrator. So that's number one. Number two would be addressing yourself in submissions. Normally for arbitration moots, we'll go the claimant is submitting, or the claimant's position, or the respondent's position. Okay, or you could go we submit, we contend, we would like to point out, we would like to emphasize. So it's the use of the word of either the party itself, like the claimant or respondent, or the word we. It's very rare that I hear counsel referring to themselves in third person, like the counsel would like to point out. And oftentimes when this form of address of yourself is being used, the counsel submits, it confuses us. So it's like, are you referring to the other side or someone else? So I would suggest not doing that, to just say, if you're acting for the claimant submits, or we submit. Okay, and even refer to your counsel for the other side, you would say, my learned friend, or counsel for the respondent. Never to say she or he when referring to your opponents doing submissions. Okay, my third general point will be on the structure. When it comes to structure, normally we would introduce ourselves first. I think that only applies in the main submissions. You don't have to introduce yourself again, especially during rebuttals and surrebuttal, to say, oh, this is me again. It's really not needed. We know who you are. So don't do that, because that will take up precious time that should be used for the points and not for introducing yourself again. Number two would be under the structure point, roadmaps. I think only 3 of you have used roadmaps. I think 1 did not. I think that's claimant number 2. I didn't catch your roadmap very clearly, so it was very hard for me to follow your arguments later. And I think that was reflected as well from the questions from the tribunal. So it's good to point out, on issue 1, this is our take on it. Issue 2, this, and 3, this, and we are putting forward arguments number 1, which is this, number 2, which is that. When you put that and you go on to say, moving on now to the first issue, or the second issue, or my first argument, then it's very clear to us exactly where you're heading. So the clarity has to be there. I think in terms of your authorities, I think both teams have put forward authorities. But I think the questions that came from the tribunal, when it came to some of the facts of the authorities, you did not fully take advantage of those questions to display your extent of research and how well you know the cases. I know sometimes the facts are not that relevant because you are citing the case because of the principles, but it's worth to, showcase the knowledge of the facts and to say that, this particular case, the facts are not, 100% similar or not that relevant except for this part. And that is why I'm relying on this case for this part. If it's bang on relevant, that's when you should highlight the facts. So I think from the submissions itself, there were times when I wish counsel would have taken advantage of the cases a lot better, especially if the co-arbitrator has pointed out a case. And I think the Enka and Chubb case was a missed opportunity by counsel for the respondent to fully use to your advantage. So I felt that there was a bit of loss of strategy there. So yes, and my final point, final main point would be when the arbitral tribunal asks you questions or asks anyone questions, everyone has to take down the questions and the answers that were given and use whatever points or concerns from that in your submissions. If you do that, then you would show the tribunal that you have paid attention, that you know exactly what the concerns are, and it would showcase that you are bold and smart. When you do that, impression is really good. And I think that part could be worked on by everyone in today's hearing. Because oftentimes, if you recall, I had to go back to say, how about this argument? And how about this point earlier? I really wished the team would have seized all these points early on and weaved it into the submissions, and then it would be a power-packed submissions and presentation. So that's all from me on general feedback. I think on specific feedback, due to interest of time, I wouldn't be able to go through everyone, but feel free to connect with me on LinkedIn. I'll be able to give my more specific individual feedback to everyone, and also it'd be good for me to keep in touch with you. I'll just leave my email and you could just contact me from there. Thank you. That's all from me. Back to you, Madam Chair.
Okay, thank you, Hui Wen. Shall we hear from our other arbitrator?
Thank you, Madam Presiding Arbitrator. And thank you so much, Hui Wen, for reminding us of the importance of using the phrase Madam Presiding Arbitrator when referring to our Presiding Arbitrator. I really think that is a very important point to take note. And in fact, last night I was Googling, how do I properly address the Madam Presiding Arbitrator, and I came up with the term Madam Chairperson. I felt a little bit ashamed, having been in arbitration practice for 2 years, and I'm still Googling this. But I definitely agree the importance of all of us having this at the back of our heads, that this is the appropriate way to address a presiding arbitrator who's a female moving forward. So I hope everyone take note of this point today. But in terms of general feedback, Hui Wen, I thought your feedback was really extensive. And I don't intend to repeat too much on this. I've typed down my feedbacks for specific all of the mooters in the Google Sheet form that has been shared. I'm not sure if the organizing committee will be sharing this with you guys, but I will be elaborating a little bit further there. In terms of general feedback, one thing that I was thinking of earlier, a point that Hui Wen has not mentioned, because I think most of my feedbacks are related to hers as well, is in terms of sharing screen. I was just thinking when the Madam Presiding Arbitrator asked one of the counsel to make reference to a case earlier on paragraph 60. I was thinking that was actually a good opportunity to request from the arbitral tribunal, you see, on whether you can share screen and show us, because one, that would save you the hassle of, I think that case was Sula America. And I think counsel just reiterated what is the position of the law, which I don't think that quite answered the Madam Presiding Arbitrator's question. So I think moving forward, if you're in the finals tomorrow, do consider sharing screen and get the leading cases prepared. Like Sula America, Enka and Chubb, MWB, and Rock Advertising. These are the cases that you guys will be citing perpetually. In terms of moving on to, okay, I'll just focus on 2 points that I have, aside from sharing screen. One of the points that I want to highlight, which is also a point that Hui Wen has touched on, is the reference to case laws and authorities. I think, in particular, the counsel for the respondent, the position on Enka and Chubb is so clear. that you could have just bite on it to say that, look, the law says that if there's a governing law clause for the contract, this is the position, full stop. You don't have to think too far away. Tribunal don't have to be too concerned of this matter. I thought there are some points which you could have bite on. And as for counsel for the claimants, the case law of MWB, is it something that you could have emphasized more, second counsel for the claimant, when you refer to Lord Sumption's arguments to bite home the point that, once there is a no oral modification clause, the law is clear, estoppel cannot come in to circumvent something that parties have already written. So I thought in terms of legal arguments, you could have strengthened it more. I know you guys have cited case laws a few times, but try to focus on the key points or the key takeaways from cases when you refer to it, as opposed to telling judges on the ratio, on the points which are not the ratio of the case. That is my second point. And my last point would also be something that Hui Wen has mentioned, which is the structure of the submission. In terms of road mapping, how many submissions that do you have? I think that's very, very, very important, because at points, when you are submitting, especially second counsel for the claimant, when you're submitting at such a fast pace, at times we will not be able to follow you fully. And at some point I was lost, on whether you are submitting on the second issue or the third issue. So I think signposting is always very important. Start off by saying you have 3 submissions. So moving on to your first submission, how many sub-submissions do you have? Yeah, it's very important to be very clear on that, to make sure that the tribunal are always with you. The tribunal is always with you. Yeah, but in terms of individual feedbacks, I'll leave it in the Google form. And yeah, feel free to connect with me on LinkedIn as well. And also I'll leave my email in the chat box for everyone to contact me for any specific feedbacks. But thank you so much for entertaining us with your submissions and also your oral presentation this morning. I think it's fair to say that the arbitral tribunal really enjoyed this session. It was a very high quality mood, I must say. So thank you all of you for your time and effort in this.
Okay, fantastic. Now, my tribunal colleagues, Hui Wen and Zening, have given some excellent tips. I hope you take them on board. Whether or not you go ahead to the finals tomorrow, these are exceptionally good points that will hold you in good practice. So do take those points on board. Now, I want to thank you all for the hard work you've put in. You've come here today to show to us your mettle and your legal dexterity. And I would say every one of you showed to us a high level of confidence. Okay, we can see how much work you've been putting into this moot, and I do want to congratulate you. Now, actually, the only downside is we are going to have to adjourn, and we're going to have a tough time choosing the winners, because both teams have done very well today. So I want you to know that. Don't feel discouraged if you don't go through to the finals. It certainly was a close fight, and it's going to be a bit difficult for us to decide on the winners in this case. Now, I do have one tip for you, and it's actually a tip that I even give my junior colleagues in practice. It's what we call a rookie mistake, and that is all 4 of you were reading from scripts. For the Alankrita, you were reading from a hard copy script, which made it a little bit more obvious to the tribunal that you needed that crib sheet. But for the other 3, the tribunal knows when you are reading from a script. And the problem with reading from a script is it makes you less fluid and less able to be agile and deal with questions that come up. So my tip to you is this: don't type out full sentences, rather have bullet points. If you know what your structure is, you have your roadmap, you have the bullet points, you should be able to put together a sentence without it seeming so stilted. Okay, so that's something you would need to be able to do. I mean, part of the art of advocacy is the ability to make an argument without the need to read out from a crib sheet. Okay, but I will say very well done. I certainly have comments and feedback for each one of you to be able to improve your submissions. I will be putting that on the score sheet. I understand the score sheets will be shared with you. So I'm going to keep the individual feedback to the score sheets. Do you have any questions? Does anyone have any questions to ask us?
I must say this is a very good opportunity to ask our presiding arbitrator, who's been teaching a lot of students and up-and-coming lawyers for her tips. And she's not billing by the hour or by the minute. So it's good for you to ask her.
I see we've all become tongue-tied now.
They're just stunned.
You've done really very well. I will say that. All four of you have done well. And the tips to get even better at this will be seen in the score sheet. So if there are no questions, but I mean, don't be shy. If you have anything to say, I mean, okay, if you don't want to say it in this context, then feel free to reach out to us separately. I think my fellow arbitrators have also been kind enough to extend their email. That's not something you don't always find busy practitioners willing to do that. So I hope you understand that you're privileged that they are willing to spend a little bit of time to share some further tips on how to improve. I am certainly willing to do that as well. So do reach out to me if you have any questions. All right. So that's it. Bailiff, do we now go into will you be sending us into sequestering us into a breakout room? Is that what?
Yes, Ms. Vasala, we will proceed first to the photo session. Yeah.
Oh, photo, right.
Yeah, thank you for the constructive feedback, Ms. Vasala, Mr. Jening, and Ms. Huiwen. And before the participants exit from this breakout room, we would like to have a photo session to remark on this mooting computation. We will count to 3 before taking the picture. Ready? 1, 2, 3. Smile. One more. 1, 2, 3. Smile. Thank you, teams and arbitrators. Thank you, the participants. The teams may now exit from the Zoom link, and we wish you all the best. Arbitrators, the deliberation sessions will take place shortly.
Thank you, Winnie.